All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 3rd, 2026. We have 7 bills on the docket, and we are going to start off with Senate Bill 775. Join us. It is. All right. So I've got one witness. This is a quick bill, so I'll just go really quickly. All right. Good afternoon, committee. Senator Smith here to introduce Senate Bill 775. This committee has seen this bill before and has actually passed this bill, I think, twice before. One thing before I get into the sum and substance of it, it's not about the merits of a gun buyback. It's just about how the gun buybacks, if they are functioned, if they are conducted, it's about the rules of the road for how they must be conducted. Now, in Maryland, I think our research showed that the first gun buyback was in Baltimore in 1974, and obviously gun buybacks are programs used to get guns, to incentivize getting guns off of the streets and into the hands of an FFL or a law enforcement agency. Someone turns in their firearm, they get money, no questions asked. Today, there are very few rules of the road governing that practice. And in some jurisdictions, they're conducting gun buybacks and just destroying the firearms without asking questions, without checking if they are stolen or lost, and without properly running checks to see if they are associated with a crime. So the bill before you, the idea actually came from something that happened in Missouri. There was an organization or a company called Gun Busters, and what they were doing was they were going to the FFL or a law enforcement agency after a gun buyback, and then because of the definition of a firearm, if it's absent the frame or the receiver, they were actually receiving all the component parts of the firearm and then putting them back onto the market. There's a really big New York Times expose about that. So that was the genesis of the bill. But then as it got onto the floor and we had more debate, certain members of the Senate wanted to say, make sure that, hey, listen, what if my firearms were stolen? Shouldn't they be checked to see that they're stolen and an attempt to be made to return those firearms to their rightful owner? Secondly, there is no legal requirement to check and see if that gun is a gun crime. So the bill puts those two requirements into the law as well. So again, it's not on the merits of conducting a gun buyback. You can do a gun buyback or you can choose not to do that. This bill doesn't touch that. It talks about how they must be conducted. It sets some rules of the roads for how gun buybacks must be conducted. If you violate this section of this new statute, you will be subject to a $10,000 fine per infraction. And if you're an FFL, the Maryland State Police can revoke your license to sell firearms in the state of Maryland. That is the sum and substance of the bill. With that, I would ask the committee for a favorable report. Stand for questions. I know we've got one panel, at least one witness to sign up in opposition, but I'll rest and stand for questions. Okay, excellent. Mr. Jocelyn.
You want me to go up there and call your next one?
Yeah, that's it.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. In opposition to 775 as it's currently written, gun buybacks by their very nature are somewhat problematic. Persons who turn in a handgun to a buyback and who do not have a wear and carry permit are transporting to a location and function that is not contained within criminal law section 4-203. They therefore have committed a crime. Further, even if you do have a wear and carry permit and you transport to the buyback on public transportation, that also is a crime. The language of the bill includes federal firearms licensees. The issue that I have personally is its clutter. No FFL is going to participate in a buyback when all of the parts on the firearm have to be destroyed. Any firearm they take into their business, they have to record in their acquisition and disposition book. And when they remove it from their inventory, they then have to have another entry indicating the disposition of that firearm. Hence, there's no financial incentive for them to participate in a buyback. The merits of buybacks aside, there's no point in having an FFL included in the statute simply because they will not participate because they have no vested interest in it. So on that basis, we can live with the bill as long as the FFLs aren't in there. If they are in there, it's simply clutter, and we would ask that you would delete that particular reference in the language of the statute. And thank you. I'll ask any questions. I'll try to answer them.
Excellent. So, thank you very much. I'll follow up with you offline about the amendment. But,
See, Senator, we're closer together on the bill than we
there
ever
you
thought.
go. You know, every blue moon, you know, we do it. All right. All right. With that, that'll conclude the hearing for Senate Bill 775. We'll now move on to Senate Bill 676, and then we have the members of the judiciary here behind you. But Senator Washington, welcome.
Thank you, Mr. Chairman, members of the committee. Great to be here again. But I think I'm going to be here again next week. Here to present on Senate Bill 676. Chair and members of the committee, on February 26th, just last week, a 16-year-old girl from Gaithersburg made threats of mass violence against Wootton High School on social media. This threat came over 2 weeks after a shooting at that same school in which one student victim suffered from a gunshot wound. This bill reclassifies the threat of mass violence from a misdemeanor to fit where it should be as a felony, and is intended to protect public safety and promote accountability. Just for background, I was provided this idea in this bill from a Homeland Security expert and Prince George's County Police Department that told me that there's a lot of these threats of mass violence that occurs that doesn't make the news or we don't see, and we see a lot of them throughout the state. The repercussions do not reflect the crime here. The current classification does not reflect the gravity of the harm caused or the risk imposed on the public. Again, in Montgomery County, there were 3 recent cases of threats of mass violence targeting Parkland Middle School, Rockville Internal Medicine, and Wootton High School. Alex Yee was 19 years old, who wrote 129 pages about a school shooting at Wootton High School. Two other observed cases occurred in Worcester County and in Frederick County. This bill, again, would just classify the threat of mass violence as a felony instead of a misdemeanor. Preventable tragedies start with early intervention, and this bill will ensure that we hold these folks accountable that makes these types of threats to our society. What this bill does not do, it does not identify other methods to prevent mass violence. It does not enforce gun control laws. It does not shortcut the due process, and does not change the existing penalties regarding imprisonment or fines. This bill is narrow and straightforward, preserves due process, and aligns our law with the seriousness of the harm when mass casualties or fatalities produced from violence could occur. For these reasons, Mr. Chairman, members of the committee, I respectfully request a favorable report on Senate Bill 676. Thank you.
Mr. Chair, thank you for bringing this bill. When I first read it, it seemed obviously intelligent, but when you gave your example of the situation with the Wootton, is it Wootton High School?
Yep.
So we have a teenager who does something really stupid, but teenagers do stupid things, and probably it's not terribly unusual for a teenager at his or her most irresponsible moment to say something like that. And it would be dreadful to saddle that person for the rest of their life with a felony charge. How do we separate the wheat from the chaff? I consider that kind of thing chaff. If they're not really intending to do it, they're just making this idle threat. That's chaff. But then you have wheat where the threats are real. How do we distinguish between the two, make reasonable distinctions between the two, and not burden someone for the rest of their life with a felony charge for a stupid statement they made when they were young and at an irresponsible moment in their life?
Yeah, look, I hear you on that, Senator, and thank you for the question. And I hope that it's still a smart piece of legislation, even though I gave you that example. Although this was a young person that did this, 16 years old, I mean, this is a threat of mass violence. I mean, those threats can cause serious bodily injury, and what we're trying to do in the state of Maryland is decrease that harm and make folks feel safe to be at school. There was a gentleman that I also mentioned that wrote 129 pages about school shootings at Wooten High School, and that's not just a thought. That is a serious case where they literally went back and wrote all these things and said what they're going to do. And we have to send a message to everyone, not just young people, that these threats of mass violence we're going to take seriously here in the state of Maryland, and they can't stand by just allowing this to continue to happen. So I feel strongly that, we just got to send that strong message. I don't want that to happen to that young person. Maybe this committee is a very smart committee that can figure out what do we do around those edges. But something like someone being premeditated and really thinking about it is still a misdemeanor versus someone just making a Facebook post about one thing or another, right?
So maybe one solution would be to add that the simple articulated threat alone would not be sufficient, but there would need to be something in order to push forward in a serious way the implementation of the threat, such as getting on the telephone and calling the school itself. Now, it's not just an idle threat. You've made a telephone call and you're scaring people, and you know that people are going to take action as a result. There are going to be all sorts of police running around. The school may get called off for the day. Who knows? Yeah. That would be a step in to realize on the threat. Maybe if we did that, the bill would be better because we wouldn't simply be penalizing somebody because they were totally irresponsible at a moment in time when they were 14 years old and said something stupid. Yeah. Does that make sense?
And that makes sense. I think that, we also have to really think about, again, those folks that make these idle threats. And, this committee is very smart and can justify what's the best course of action for that situation. But I feel strongly that we have to send a message to everyone that threats of violence, mass violence, 5 or more people is serious. And just imagine, I don't know about you, but when I was in high school, we had a bomb threat almost every week called into our school for like a whole full year and interrupted our cases. And it was just a misdemeanor according to the law currently when that does happen. And if there was a message sent that this would be a felony, it will stick with you, maybe we wouldn't have those types of threats that are issued throughout the state. And I think we have to take every threat very seriously. Whether you post on Facebook saying, saying that they're gonna, have a bomb threat, there's a bomb at such and such school, we should take that very seriously. And that's just a simple comment. That's not just thinking about it, but that's something that our school system will take seriously and evacuate the school just to search it, just because they're being preemptive. And so we just got to send a message that this is a very serious issue.
Thank you for bringing it along. I really appreciate your responsive answers to my questions.
You got it. Thank you, sir.
Further questions from the committee? All right, seeing none, thank you very much, Senator. Thank you. All right, with that, that'll conclude the hearing for Senate Bill 676. We'll now move on to Senate Bill 716, which is Senator Folden.
Which one? Oh, sir, I'm sorry. 760. Okay, thank you. Bring up my witness. Yes. How are you, sir? Good to see you. Mr. Chairman, esteemed colleagues of Judicial Proceedings, for the record, William Folden, State Senator representing the 4th Legislative District. Before you today is Senate Bill 716, Courts and Judicial Proceedings Charging Documents for Law Enforcement Officers. This bill makes a straightforward but important clarification in Maryland law. It adds special police officers for the Maryland judiciary to existing provisions governing the charging of law enforcement officers with a crime. Current statute does not explicitly include them in provisions addressing charging procedures for law enforcement officers. This creates an inconsistency in how similarly situated officers are treated under the law. The bill simply ensures uniform application of existing charging procedures and aligns the statute with the realities of modern courthouse security operations. Clarity and consistency in our statutes promotes fairness, transparency, and confidence in the criminal justice system. It also really is a common sense measure. It's the idea that we have a responsibility to ensure our courtrooms are safe for the judiciary as well as all those in attendance. And when certain types of complaints are brought up, the removal of someone from their security or police procedures that are necessary for the safeguard of the courtroom being extended causes other strains on the judiciary and the safety of those courtrooms. So with that, I'm happy to take questions, but I would ask for your favorable report on SB 716, and I'll turn it over to my panel. Chief Judge.
Thank you, Senator Folden, and thank you for sponsoring this. Good afternoon, Chair, members of the committee. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court. As Senator Folden explained, Senate Bill 716 is a focused technical fix to the Courts and Judicial Proceedings, Section 2608, ensuring that the Maryland Judiciary Special Police Officers, the bailiffs who keep our courthouses safe, are expressly covered by the statute governing charging documents for on-duty incidents. The bill does not expand powers or create new procedures. It aligns the statute with current practice and clarifies that when an allegation arises from duties performed by these officers, the application is forwarded immediately to the state's attorney rather than going to a commissioner. Bailiffs in the District Court of Maryland are sworn special police officers responsible for maintaining safety and order across our courthouses statewide, serving as part of the more than 2,000 dedicated staff that support the District Court's mission. Their structure is centrally managed through District Court headquarters, which establishes and enforces the uniform policies, procedures, and security standards that guide the bailiff operations in all 33 courthouses in 12 districts throughout the state. Within each district, bailiffs report through a defined chain of command from supervising or lead bailiffs to administrative clerks and administrative judges, while headquarters provides the overarching governance, training, expectations, operational protocols that ensure a statewide unified approach to courthouse security. The bailiffs perform frontline security and face on-duty interactions like other law enforcement. Often the situation is simple as placing a hand on the shoulder of a disruptive citizen and the bailiff guides them out of the courtroom. But what we've seen on a number of occasions is that sometimes the citizens then go to the commissioner's office and swear under oath that an assault occurred. And this creates not only an actual conflict of interest, but an apparent conflict of interest also. So that commissioner can't hear that case because it's a bailiff that works in district or in that courthouse. So then we have to bring an out-of-county commissioner in, and we'd have to assign either a senior judge or a judge from another location to come hear that case. All we're asking is that rather than it be coming in front of the commissioner, that it be taken to a state's attorney, and then we'd abide by whatever. If the state's attorney decided to pursue charges, we would follow through. What's happening right now is we have to place the bailiff on administrative leave. Sometimes it takes us more than a day to get another commissioner or another judge in place. This unfortunately places a burden on the local courthouses, also stress for security personnel, as Senator Folden mentioned. The simple change to the law promotes consistency statewide, due process, and public confidence without creating any type of conflict of interest for the district court. We'd respectfully request a favorable report. And now I'd like to introduce you all to Steve Barlow. He is the director of the District Court Security. He doesn't get out of the office very much, so this is his first time appearing before this committee.
Thank you, Your Honor. Good afternoon. My name is Stephen Barlow. I serve as the security manager for the District Court of Maryland and am a sworn special police officer under Public Safety Title III. I began my career as a Maryland State Trooper and following retirement, continued my public service with the Maryland Judiciary. I started as a district court bailiff, advanced to lead bailiff, and then to supervising bailiff, overseeing security at 5 district court locations on the Upper Eastern Shore. Our district court bailiffs are sworn special police officers and serve as the first line of defense for our courts. Similar to sheriff's offices in the circuit court, we provide courthouse security for the district court system. We operate screening stations, patrol courthouse grounds, protect judges and staff, maintain courtroom order, and ensure public safety. Last year, our bailiff SPOs screened nearly 2.5 million visitors statewide, recovered over 8,500 knives, 4,000 canisters of pepper spray, and 64 firearms. They also handled more than 300 security incidents and investigated 69 threats against judicial officers, clerks, and fellow bailiffs. Despite performing law enforcement functions in a heightened threat environment, there is currently no requirement for an investigation before criminal charges may be issued against a judiciary special police officer for actions taken in the performance of their official duties. This is a significant gap. In recent years, 3 to 5 bailiffs annually have faced charges stemming from on-duty actions. When that occurs, they are removed from duty pending investigation, creating staffing shortages, operational strain, and serious morale concerns. Even when acting in good faith in accordance with training and lawful authority, they face the uncertainty of prolonged legal exposure without preliminary review. The proposed legislation does not create immunity or shield misconduct. It simply ensures that, as with other law enforcement officers in Maryland, an appropriate investigation occurs before charges are issued for actions taken in the line of duty. This change promotes fairness, consistency, operational stability, and accountability. I respectfully urge your favorable consideration. Thank you for your time.
Thank you very much, Mr. Barlow. Questions from the committee for the panelist, for the sponsor of the bill? All right, seeing none, thank you all very much. Thanks.
Thank you, members of the committee.
All right, so with that, that'll conclude the hearing for Senate Bill 716. We'll now go on to Senate Bill 736. I see Carlotta's here. Come on up. Up.
Oh, okay, then I'm going to talk to you. I'll be right outside the door.
Good afternoon, Chair, and good afternoon, Vice Chair, and esteemed members of the Judicial Proceeding. For the record, my name is Omar. I'm the Legislative Director for Senator Benson. Senate Bill 736 is a critical bill that is vital toward modernizing Maryland law to combat child exploitation significantly, to include AI-generated imagery. This bill adds in expanding protection and raise the age of images used by artificial intelligence from 16 to 18 years old. These include computer-generated images that are indistinguishable from children, addressing a severe privacy concern of users. Most importantly, children from their likeness being used or abused without permission. With the expansion of powerful technology, important guardrails should come to protect the children of Maryland from explicit abuse coming from unwanted entities or people. This legislation is carefully drafted and does not apply drawings, cartoons, sculptures, or painting, ensuring that protected expression remain unaffected while still protecting children. Increasing the maximum age from 16 to 18 of a certain child that may not be depicted in certain visual representation. Altering the penalty for knowingly possessing and intentionally retaining and knowingly or intentionally accessing or viewing certain visual representation. Authorizing a person depicted in certain visual representation bring a certain civil action, and requiring the Attorney General to submit certain annual report by December 1st. This problem of unauthorized artificial intelligence plagues our children and school system and needs to be penalized to protect our innocent children from the harm and abuse of internet in the age of AI. This bill would allow victims to bring civil action for damages and would help to deter further exploitation from unwarranted actors. Senate Bill 736 helps to close many of the technology loopholes in the age of AI image manipulation that would negatively affect children, leading to severe bullying, mental health issues, and in worst cases, suicide. This bill is essential to protect our children in this new unprecedented time and create a level of transparency, accountability with annual reporting requirement. Within the bill, it requires annual reporting for the Attorney General on enforcement trend to help make more informed decisions on this bill. We must now support Senate Bill 736 to ultimately make a positive impact on the next generation. This bill positions Maryland as a leader in protecting children against modern digital exploitation. The great state of Maryland must now join Alabama, California, Pennsylvania, and Illinois, and many other states in taking a stand against abuse of artificial intelligence upon our children. We must take responsibility and action now to make sure that we protect not only the children of today, but upon our children of tomorrow. We are forced to live in the era of AI. For that reason, the Senator urged respectfully for the committee for report on Senate Bill 736, and thank you for your consideration.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 736 regarding child sexual abuse materials, also known as child pornography. There's several parts to this bill. Certainly one of the things at its core is raising the age for child pornography from age 16 to age 18. In reviewing this bill, I will say that I also looked at Senator Henson's wonderful bill that's in rules right now, Senate Bill 989, which takes a very similar position. And I realized that this bill in front of you now still uses the term child, which is defined in the general article as under 16, and as Senator Henson did in her bill, it would be more correct, perhaps, under our code to use under a minor, because a minor is under 18. That's, of course, a technical matter, because I will say, working in this field for so long, the child sexual abuse cases are some of the hardest, the most harmful, the most horrific in a field where there's no superlatives. They all are terrible cases. But these are children who are sexually abused during the creation of child pornography and sexually abusive material, and then they repeatedly feel that experience of being abused as the image is circulated around the world on the internet. And this bill really is a way to help recognize that and to also create some civil penalties, as well as some good information for prosecutors, like the prosecutor you'll hear from next about guidance and how to deal with computer-generated images. For these reasons and the reasons you'll hear from the witnesses after me, the Maryland Coalition Against Sexual Assault urges a favorable report on Senate Bill 736.
Good afternoon, Chair, Vice Chair, and members of this committee. My name is Zachary Payne. I'm a lifelong resident of Cecil County. I'm currently a special victims prosecutor in the Cecil County State's Attorney's Office, as well as having the utmost pleasure of being an adjunct professor where I teach cyber law, cyber crime, and related material. Your Honor, and again, I'm a litigator, so I may slip out with your honor, but I apologize to members of this committee. We are requesting a favorable report on SB 736. This bill, in part, strengthens the penalties for possession of child pornography. As Ms. Jordan stated, The body has already recognized the harm that these children suffer every time one of these images is distributed by allowing for a maximum or permanent injury score on the Maryland sentencing guidelines. I used a quote when I prosecuted a production case a few years ago. There is nothing as certain in this life as death and taxes. I would add to that corollary here today that there is nothing also as certain as things and materials uploaded to the internet. Raising the penalty to 10 years gives prosecutors additional tools to be able to address this incredibly growing problem. The Maryland State Police provided us statistics that last year they had 13,000 cyber tips. This year, in 2025, we had 21,000, a dramatic increase. And I can also assure you that in my own practice, I am also seeing a dramatic increase not only in the offenders producing, downloading, and retaining child pornography, but also in the volume. We are seeing more and more and larger caches of these images. And at this juncture, they are representing a 5-year misdemeanor penalty. That is nowhere near enough to represent that the harm that that child and those children had to suffer in the creation of this material. I would point out Maryland Criminal Law 3307, sex offense in the third degree, is a 10-year penalty that also would represent most of the materials that these children, most of the offenses these children had to suffer. My time is up. I would request a favorable report on SB 736. Thank you so much for your time.
Chair and members of the committee, my name is Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute in support of Senate Bill 736 for 3 reasons. It modernizes, it strengthens, and it centers justice. It modernizes our law to reflect the reality of today's digital exploitation. It also strengthens the consequences for those who traffic in the image of child sex abuse, and it centers justice for the victims. It gives them a meaningful civil remedy. 736 will align Maryland's protections with this basic moral intuition that we all agree with, that every minor deserves the law's full protection from sexual exploitation. And current law draws an artificial line around the age of 16. But any depiction of child sex abuse under the age of 18 are unacceptable and as such should be unlawful. You know, this is at a time when artificial intelligence and sophisticated graphics can make images that are indistinguishable from the actual identifiable child. And so if we don't update this statute, it allows predators to hide behind this new technology and not be held accountable for the harm that they choose. This bill increases penalties for those who have the mens rea, who knowingly possess or retain or intentionally access these images. You know, for our organization, protecting children from sexual exploitation is not a partisan issue. It's a moral obligation. It's a basic requirement of a just society. And 736 will strengthen Maryland's resolve to stand with the most vulnerable and to confront those who try to exploit them, even if that's just using a camera lens or a keyboard. And for those reasons, we urge a favorable report to Senate Bill 736.
All right, questions from the committee for this panel? All right, seeing none, thank you very much. All right, is Joe St. George here? Virtual. Oh, that's virtual, sorry. That's virtual. Gavin Potashnik. I don't.
If I may.
Sure.
Both Mr. Potashnik and I did sign up to testify here today. However, Mr. Potashnik is currently engaged in a jury trial, so it's going to be one or the other of us from my office. So he apologizes for his absence.
Excellent. Send him our regards.
Absolutely, sir. Thank you.
All right. All right, so we'll hear from Joe St. George. Welcome.
Oh, thank you. Hi, my name is Joe St. George, Chief Legal Officer of Women of Color for Equal Justice. I want to thank you for this opportunity to testify I'm a personal victim of child exploitation at 8 years old, not by technology, but this is a serious problem. Child exploitation rarely begins with physical contact. It begins with grooming, manipulation, secrecy, psychological control, and our legislative materials explain grooming is a gateway to this crime. National data show that 1 in 4 girls and 1 in 20 boys experience sexual abuse before the age of 18. Children are sexually exploited is not hypothetical. It's measurable, growing, and increasingly digital. The Center for Missing and Exploited Children received 36.2 million reports of suspected online child exploitation in 2023. The U.S. Department of Justice has reported also explosive numbers, and law enforcement agencies report rapid growth in AI generative exploitive imagery that mimics real minors, complicating prosecution and victim identification. Digital exploitation is a pipeline into physical exploitation. The digital landscape has changed the scale and speed of exploitation. Computer-generated images indistinguishable from an actual and identified child are increasingly used to normalize abuse and evade enforcement. This bill would do several things: preserve parental rights regarding lawful images of their own children, provide an affirmative defense for good faith destruction or reporting, and it empowers victims to pursue civil remedies without requiring a prior criminal conviction. This is not about censorship. It's about protecting children from sexual exploitation in both physical and digital spaces. And African American and Latino girls are disproportionately represented amongst trafficking victims in the U.S. and around the world. So we ask that you please support this bill and give it a favorable report. Thank you so much, and good seeing you, my dear friend, Senator Smith.
Hey, good to see you. Thanks a lot, and thank you for your testimony. All right. We'll now move on to Peggy. You're up. Welcome. I think you're still on mute. Let's go ahead and unmute.
Mute.
There you go.
Can you hear? Okay, thank you.
can.
My name is Peggy Cairns. I'm with the Maryland Coalition Against Pornography, a nonprofit organization since 1986. I am a retired law librarian from the Justice Department and a grandmother and a mother. I thank the committee and Chairman Smith and Senator Benson for sponsoring this bill. Many of the things I was hoping to say today have been said already. I won't go into the repetition of them, but I just want to point to some statistics that are in the document that I submitted for my written comments. There is a chart. You will see that artificial intelligence reports of the National Center for Missing and Exploited Children for 2024, the latest one they have gone up by 1,325%. And we know these are just the things that are being reported. There's much that goes unreported. It's an incredible number of incidents out there. It's getting worse. And artificial intelligence gives such easy, cheap, free access to this technology to anyone that wants to perpetrate it. Our children are at risk. So I hope that you will, we urge a favorable report on this bill, and we commend the fact that civil actions will be options for the victims. Thank you for this opportunity.
Excellent. Thank you very much, and thank you for your testimony. We turn it over to the committee for questions. Seeing none, that will conclude the testimony and the hearing for Senate Bill 736. We're now going to move on to Senator Folden. Are you ready to go? Sir. Awesome. Senate Bill 677.
Mr. Chair, esteemed colleagues of the Judicial Proceedings Committee, for the record, William Folden, Maryland State Senator representing the 4th Legislative District. Before you today, Senate Bill 677, Public Safety Handgun Permits relative to firearms training courses. This legislation is to update Maryland's firearm training requirements for applicants seeking a wear and carry permit. Currently, Maryland requires an applicant for an initial handgun wear and carry permit to complete a minimum of 16 hours in-person instruction by a qualified handgun instructor and a minimum of 8 hours for renewals. This training covers state firearm law, home firearm safety, handgun operations and mechanisms, and includes a live fire qualification component requiring at least 25 rounds with a minimum accuracy standard. This bill builds upon that principle. It clarifies and modernizes the training requirements so that they reflect the current best practices in firearm safety, legal education, and responsible decision-making. Clear statutory standards benefit everyone: applicants, instructors, law enforcement, and the public. When expectations are transparent and consistent, especially relative to handguns, compliance improves and ambiguity decreases. As policymakers, we have an obligation to maintain a permitting system that is fair, defensible, and grounded in public safety. Updating and clarifying these training requirements helps us meet that obligation. And with that, I would ask for your favorable report of Senate Bill 677, and I'll turn it over to my panel, and I'm happy to take any questions.
Thank you, Mr. Chairman, members of the committee. John Jocelyn, 2A Maryland, speaking in strong support of Senate Bill 677. House Bill 824 was passed in 2023 in response to the 2022 Bruin decision, which declared Maryland's good and substantial requirement for wear and carry permit to be unconstitutional. As such, the bill was not as well thought out as it might have been. It was a time of high emotions, and people were afraid that things were going to happen. There was going to be violence in the streets. Experience has shown that was not the case. Unfortunately, during this time period, we were unable to improve the content of the carry permit courses, and we're hoping that today, in light of the experience with the carry permit holders for 3 years, that you will realize that the training that was mandated back in 2023 really was not germane to the topic. And Senate Bill 677 addresses those shortcomings and adds some practical, real-world, functional performance standards that we need to teach students properly. We do ask for your favorable report on this. We think it's an excellent bill, and it's well overdue. Certainly try to answer any questions you may have.
All right.
Thank you.
Thank you very much. I don't see Mark Pennick here, but.
He's out sick.
Yeah, he took a fall on ice, and I don't know what his situation is today.
Oh, no. Can you please send him our regards? I hope he gets well soon. Yeah. I'll reach out to him. All right. Seeing no questions, that will conclude the hearing for Senate Bill 677. We'll now move on to Senator James was here. All right. We're going to take a 30-second break. Yep. All right, we'll now hear from Senator James with Senate Bill 906.
If you just give me 1 minute, I have a couple of panelists coming in, I think. I have a state's attorney and, pardon me? Well, and Senator McKay have a bill too? Is my other witness, is Mr. Brodnick here? Is Mr. Brodnick here? I have, maybe so, let's do that, because I have a parent that's, yeah, and I don't want that person not. All right, so give me, yeah, let me know.
Okay, excellent. We're going to go now to Senator McKay with Senate Bill 744.
Good afternoon, Mr. Chair. Vice Chair's missing. Members of the committee, thank you for the opportunity to testify and present Senate Bill 744. Senate Bill 744 addresses a clear and harmful gap in Maryland's law. While the courts issue custody orders intended to protect children and establish stability, there is no clear gradual enforcement mechanism for those who are knowing or willingly violating through interference. When a person entices, persuades, or withholds a child from lawful custodian in violation of court orders, the consequences can be severe. Children experience confusion, instability, and emotional harm. Lawful custodians are left with limited options, and law enforcement often lacks the structured framework for responding proportionately. Now, Senate Bill 744 provides that framework. You see, the bill applies specifically to the custody orders issued under Maryland court jurisdiction. It makes unlawful to knowingly or willingly interfere with a court-ordered custody arrangement by enticing, persuading, or withholding a minor from lawful custodian, court-appointed guardian, or a person standing in as a parent. Importantly, Senate Bill 744 takes measured and a balanced approach. It does not immediately criminalize the first violation. Instead, it establishes a gradual penalty structure. The first offense results in a written warning. The second offense may result in a civil fine up to $250. The third offense may result in a civil fine up to $500. Only after repeated violations does the conduct rise to a misdemeanor, up to 30 days for a fourth offense, and up to 1 year for a fifth and subsequent offenses. You see, this structure prioritizes compliance over punishment. It gives individuals clear notice, it gives law enforcement clear guidance, and it gives the court orders the respect that they deserve. Senate Bill 744 is about reinforcing stability for children. It's about ensuring that custody determinations are not undermined by repeat interference. And it's about providing a fair, proportional enforcement tool that only escalates, I repeat, that only escalates only when misconduct continues. Children deserve consistency. Court orders deserve enforcement. And families deserve clarity. For those reasons, Mr. Chair, I respectfully urge a favorable report for Senate Bill 744.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Christina Rilo. I'm a Baltimore County resident and State of Maryland employee with joint legal and physical custody of my 4 children. I come before you today humbly requesting your support as a voice for the socioeconomically disadvantaged, myself included, who are desperately in need, who are seeking much needed and long overdue legislative reform. When my ex-husband violated our court order for over a year by withholding my children during my scheduled parenting time and excluding me from important decisions involving their health care and education, I had no effective means for enforcing the court's orders. To protect my parental rights, I was forced to take out a home equity loan and spend nearly 2 years in family court. Most families do not have this option. While I still maintain joint physical and legal custody of my 4 children, I'm now working 3 jobs out of necessity to cover the legal fees I incurred because there was no other means to hold my ex-husband accountable and compel compliance with the court's orders. I believe most anyone would agree that this process, as it currently exists, falls short of the definition of justice, defined as the moral principle of ensuring fair, impartial, and proper treatment of individuals through a legal system that upholds rights and assigns deserved consequences. In co-parenting dynamics where there's a significant power imbalance, the socioeconomically disadvantaged party is truly left without recourse. In situations such as these, those of us who lack the financial means, resources, and/or education are unjustly placed at a significant disadvantage when attempting to defend and protect our parental rights. SB 0744 would close enforcement gaps, discourage parental alienation, and ensure access to justice so that children can maintain meaningful relationships with fit parents. I respectfully ask for your support of SB 744 and hope my testimony has raised awareness of the disparity experienced by fit, willing, and able parents who simply lack the financial means to hold their co-parent accountable for violating court orders. Thank you for your time today.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for your time and consideration. My name is Brian Fitzgerald. I'm a father, and just like everyone in this chamber, I'm also someone's child. SB 744 addresses a narrow and defined issue, repeated, knowing, and willful interference with a valid custody order issued by a Maryland court with proper jurisdiction. This legislation does not apply to emergency protective actions. It does not override judicial discretion. It does not criminalize isolated mistakes or scheduling misunderstandings. It applies only after a court has exercised jurisdiction, evaluated the circumstances, and issued a lawful custody determination. The bill establishes a graduated enforcement framework, a documented written warning for a first violation, modest civil fees for subsequent violations, and only after multiple willful violations does the conduct rise to a misdemeanor. That progression is intentional. It ensures proportionality and preserves due process. The purpose is not punishment. The purpose is consistency. When repeated violations occur without structured enforcement, the authority of the court is diminished and instability for a child increases. The legislation creates documentation so repeat violations are recognized as repeat violations. It provides clarity so expectations are predictable. It reinforces that custody determinations issued by Maryland courts must carry meaningful weight. SB 744 is limited in scope, proportional in response, and focused solely on repeated intentional noncompliance. I respectfully request your favorable consideration to ensure that custody orders remain enforceable, consistent, and protective of children. Thank you.
Chair, members of the committee, thank you for the opportunity to speak today. My name is Jerron Hurt Sr., father of Jerron and Joshua, known to many as the Hurt twins. What began as a simple family tradition of sharing memories grew into over 1 billion views on social media. But behind those views is a father who had to enter family court to protect his sons. As I navigated the system, fathers from across Maryland reached out, sharing their stories, different backgrounds, different incomes, same struggle, court-ordered parenting time denied or no accountability. That's why I founded the Hurt Fathers Advocate Corporation. Over the past year, I've studied how courts operate. The standard is the best interest of the child, yet when a parent repeatedly violates court-ordered access, the child's best interest is replaced by the will of the alienating parent. When alienating parents face no consequences, it only empowers them to continue. Just like raising a child, accountability is essential. We must teach that actions have outcomes. SB 744 brings those accountabilities and ensuring children aren't left caught in endless cycles of alienation. We know children with active fathers face higher risk, depression, academic struggles, justice system involvement, and in Baltimore, nearly 58% of households with children are single-parent homes. When parenting time is withheld and courts do nothing, we deepen those outcomes. SB 744 isn't about accountability. SB 744 is about accountability. It creates escalating consequences for repeated willful violations of court order access, because without consequences, violations will continue. My sons missed a family funeral due to denied access, and the guardian litem suggested we could just have another, but some moments can't be replaced. This bill isn't about punishing mothers or fathers. It's about protecting children from prolonged alienation. When the system holds parents accountable, children's relationships are protected. So I ask you, will Maryland enforce parenting orders or allow repeated violations to harm our children? SB 744 ensures children gets what they deserve. Thank you.
Excellent. Thank you very much, Senator. Questions from the committee for the panel? Senator West.
Thank you, Mr. Chair. Could I ask the sponsor, looking at page 2 of the bill, so we've got these gradations. A person who violates the section says for a first offense, they'll receive a written warning. Who would give the written warning to the violator?
Who are we? I'm sorry?
Who would give the written warning to the violator?
The responding officer, sir.
A policeman, okay.
Yes, sir, please.
And then the second offense is subject to a civil fine not exceeding $250. I assume, once again, that it would be a policeman who would write out a fine?
Yes, sir.
Okay, the third offense is another civil fine not exceeding $500. Again, you're talking about a policeman imposing the fine, correct?
Correct, sir.
And then the fourth offense is misdemeanor and possible imprisonment not exceeding 30 days. That would go to either the district or the circuit court for them to make that determination?
Correct, sir. Is there something that you're suggesting to clear that up?
No, I'm just trying to figure out what this would be. So for the first three offenses, you've got policemen on their own deciding to issue warnings and civil fines. And for the fourth offense, the person would have to be taken to court. And for the fifth offense, once again, looks like it's a misdemeanor and a imprisonment not exceeding a year. That, once again, would be in the court, right?
Correct, sir.
Okay, thanks. I'm just trying to clarify how the system would work.
Yes, sir.
All right, thank you very much, Senator West. Further questions from the committee? All right, seeing none, thank you all very much. Thank you. All right, is Robert, it's virtual. Let's see who else is here. Okay, we're going to hear from our one more proponent joining us virtually, Robert Garza. Welcome.
Good afternoon, Chair and members of the committee. My name is Robert Garza. Thank you for the opportunity to testify in support of 744. SB 744 does not change custody law in Maryland. Custody determinations remain in circuit court and continue to be governed by the best interests of the child standard. This bill does not alter that framework. What this legislation addresses is enforcement after a valid court order already exists. In Maryland, circuit court determines custody under the best interest standard. When the legislature defines certain conduct as criminal, the court acts in criminal jurisdiction to determine whether the elements of that offense are met. These two are separate legal functions. SB 744 does not authorize criminal courts to determine custody. It does not ask law enforcement to reinterpret family law. It applies to valid existing court orders and repeated willful interference. Maryland already recognizes this structure in other family areas. Protective orders originate in civil proceedings, yet violation is criminal. Child support orders are civil, yet willful non-payment may result in criminal non-support. The order remains intact. The violation is what triggers enforcement. This bill follows that same principle. Repeated interference with court orders, custody in itself is harmful to children. Chronic instability undermines their sense of security when court orders are repeatedly ignored without meaningful consequence. The authority of the court is weakened. SB 744 reinforces judicial authority. It strengthens compliance with lawful court orders. It preserves judicial discretion, and it creates accountability after repeated willful violations. Court orders are not suggestions. Children deserve stability, and the rule of law deserves enforcement. I urge favorable report for SB 744.
Excellent. Thank you very much, Mr. Garza. Questions from the committee for Mr. Garza? All right, seeing none, thank you very much.
Thank you.
All right, that'll conclude the testimony for the proponents of the bill. We'll now move to the opposition panel, and we have Michelle Smith and Lori Ruth, both of whom are here in person. Welcome.
Thank you. Mr. Chair and members of the committee, my name is Michelle Smith. I'm having a medical issue, so I'm a little bit weak today. I'm not going to be as vibrant as I always am. I would prefer to sit. Thank you so much. Just turn my microphone. There we go. Thank you. And I can't see everybody, but sorry, I'm using my time with this nonsense. I am here on behalf, thank you. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. We are in opposition of this bill. There are several reasons. Two reasons are that the outcome that I believe the proponents are asking for, criminal sanctions for the unjustified withholding of children under custody orders, already exists in Maryland law. We have Section 9105 under the family law that directly addresses this issue. We also have contempt law, and that does have incarceration as a possible outcome when a person violates a court order under contempt law. Both of those avenues are available whether a person has an attorney or not. The difference in this law versus the law that already exists is, in my opinion, and having been a prosecutor for 20 years before I became a private counsel in family law matters, the implementation of this law is going to be extremely difficult. Senator West already asked questions, which I think were very pointed and on point. The officers at the scene, if you can imagine, at 1 a.m., a call comes in that a child is being withheld under a custody order. How is that road officer going to gather all of the information that's required to understand what the order even means? I don't know if everybody on this committee understands that very often people come to agreements in these cases, which are then incorporated into a court order, but the agreement has a lot of legal mumbo jumbo in it with regard to what the actual language means. How can a police officer possibly get to the bottom of that at the scene of a home? In addition, the circuit court judges are, thank you. The circuit court judges will hear the case at the 5th offense. District court judges will hear the case at the 4th offense. And district court judges are not, they don't have jurisdiction over family law custody matters, and they're not trained in this area of the law, nor do they have time on their dockets. For all of those reasons, we urge an unfavorable report.
Good afternoon, Mr. Chair, members of the committee. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. We are also here in opposition to Senate Bill 744. I think, you've heard from the family law section, and I really urge you to read the written testimony, but I want to also address this from the point of view of our clients who are victims and survivors of domestic violence. I think the proponents of this bill simply can't understand how this can be weaponized against protective parents and survivors. And so I really have to say that I don't, I can't see a way that this makes sense. And it's for the reasons that Ms. Smith said, but it's also because anybody who's facing the possibility of criminal charges may be too fearful to do what is the most safe for their children at that time. And although the proponents say this is not punitive, it is certainly, in my view, not focused on the best interest of the child. We always say in family law cases, you can't do things in a cookie-cutter manner. I certainly don't want a police officer on my front porch deciding whether something I did was willful and knowing. I mean, this is something that judges have to struggle with at times, and in criminal prosecutions, the willful and knowing is a very difficult standard. So asking a law enforcement officer, just because the other party called and said she didn't return the children or she's 2 hours late, the child may be throwing up in the bathroom and I couldn't send them back. The child may be, so it was willful and knowing in that sense. I couldn't put the kid in the car without the kid throwing up. But it's not necessarily willful and knowing in a criminal intent manner the way this bill contemplates. I mean, it is drafted really poorly. But I think we also pointed out on the other side of the street that, you know, the 4 times you get to do this before you get to the criminal time, by that time the circuit court is going to have been able to have a hearing and resolve it in the family law manner that they always do. So there are a plethora of other reasons, but for those reasons we oppose this bill.
Excellent. Thank you very much. We have questions from the committee. We have Senator Charles first, then Senator West.
My first question's about the police. You mentioned that when the police are called to the scene, we're expecting them to understand, you know, make a decision on something they may not have all of the full details. To me, it seems kind of clear. Like, the police officers, they can badge in, they can radio in and say, hey, how many times has a call come to this house for this issue? If this is the 2nd time, this is now the 3rd time, or this is now the 4th time, they should be able to get that information, shouldn't they, for the same particular issue?
I would hope that they would have that information, yes, Senator Charles, but I would hope that they would also have the other information of had civil citations been issued before, because that would be required under this bill as well.
Right, and they should be able to radio in and get that information.
I would hope so.
Right, so that shouldn't be an issue if they can radio in, do you think?
I don't think so, but I was pointing out a different issue.
Can you explain that issue?
Yes. A lot of times when people come to an agreement, which is the majority of cases, where they come to an agreement, they write it out with legal language, either with an attorney or without. And sometimes it's complicated. You know, dad's going to have every Thanksgiving from 9 to 6, unless he's traveling, and then he's going to have this or that other provision. So if mom had the child on the Thanksgiving, dad could call in and say, I'm supposed to have the child on Thanksgiving. The police officer would get to the scene and say, show me your court order. And the court order would simply say that it's incorporating but not merging the parties' written agreement. There would be no language in the order about Thanksgiving. And that happens quite often. So the police officer wouldn't be able to get that agreement language.
And for that particular issue, if the person that feels like they're being violated, the order shows that they're supposed to have the child on Thanksgiving, and they show up to get the child on Thanksgiving, and the order specifically says they're supposed to have the child on Thanksgiving unless, to your point, and the other party chooses to not give up the child, it seems like it's clear cut, black and white, that the order says they should have the child, they're there to pick up the child, and this person is now violating the agreement.
I agree with you, but what if they don't show the agreement? What if the agreement said something, just anything, that would have been a reason that the other party didn't give the child, a good reason, and the party who's being wronged chooses not to show that agreement?
Well, I think that has a lot to do with our judiciary needs to be clean up a lot of these orders and make sure things are crisp, black and white, so that you can actually see and you won't run into these problems. To your point, there are a lot of people that can come to an agreement, but for those that can't come to an agreement, some of the most egregious cases, hence why we have a lot of legislation that comes forward, because there are issues at hand. And on top of that, I hope one day we'll all be standing on the same side of the podium, but for some reason, for the last 15 years since I've been coming out here trying to advocate on behalf of family rights issues, we've never been able to all be on the same podium, but hopefully one day we can. But I want to go to the next question that I have, and that was, you mentioned something about if the child is spitting up, or they're supposed to be back at 6 o'clock and the child is not doing well, shouldn't there be some level of communication there? Like, hey, I know I'm supposed to be there at 6. You done drove 4 hours to come get this child, get the child for the order, and they're spitting up, so it's going to take me some time to get there, as opposed to having the other party sitting out there for hours on end, waiting for some level of communication when nobody knows anything except for the party that's violating the order?
Well, Senator Charles.
Once upon a time.
Yeah, right, I know. Yes, one hopes that there is a level of communication, but my issue is with how this can be manipulated against the party who has been a subject of coercive control and a power imbalance. So what we see is there may be an order that says the child's going to come 6 o'clock on Friday and be returned at 6 o'clock on Sunday. But then over time, there's an informal order that it could be the next morning or Monday morning. And then something happens between the parents or the two custodial parties, and the person who feels wronged and is angry then calls the police and says, it's supposed to be 6 o'clock on Friday, when for a year and a half it's been Saturday morning at 9 a.m. without them ever bothering to go back to court and change the court order. And so this person's going to get caught in a web of being accused of doing something that the law enforcement officer standing on the front porch doesn't have any ability to assess. And so maybe the first time they get a warning, but if it happens again, and I've been doing this domestic violence work for over 20 years, or for almost 20 years now, and the ways that well-intentioned laws can be used against the constituency that we represent are, endless. And so, yes, I want communication, but it doesn't happen in such a clean-cut way that a bill like this is always going to get the right answer. And I also just want to point out that there's a lot of research that shows that criminalizing parents is very, very detrimental to the children. So I respect the proponents talking about, wanting to do what's best for the children. I think we are all on the same page in that way. It's how we get there that differs, but it is a bad idea to criminalize parents. The children suffer trauma from that. And that's in my written testimony. I just gave you 2 sites in my written testimony.
All right, so I'm going to ask you on the next bill that we do to pull criminalization for not paying child support or those things, pull that out, because that's a huge criminalization of family issues.
Child support's a big mess. I think we can all agree on that too.
Can I get you on the record getting your support on that bill?
I don't know what the bill is, but what I do now is just about domestic violence. The section council, talks about child support bills, so.
All right, thank you.
Thank you.
Thank you, Mr. Chair. So for Ms. Smith, your testimony refers to Section 9-105 of the Family Law Article, as well as Maryland Rule 15-206, which you say gives the court certain powers. So I'm looking at the bill. The first offense results under the bill in a written warning. Does the court at the moment, the family law court is the circuit courts, not the district court. We're talking about the circuit courts here. So at the moment, if there's a first offense, does the circuit court have the power to issue a written warning to the party who the court finds responsible for the problem?
I know of no legislation that allows a court to issue a written warning to anyone.
Don't they issue a written order that would affect it, which would in effect be a written warning to the perpetrator, to the culprit, that he or she shouldn't do it again?
I think that's a stretch of an interpretation of a very poorly written bill.
Okay. How about the second offense, the civil fine? Does the family law court currently have the ability to fine someone who's not in compliance with the court's prior order?
That's an interesting question. Under Section 9105, as well as under the contempt law for enforcement of these orders, the court does have a wide range of options for issuing an order after finding that the person did unjustifiably deny access. I have seen and heard about cases where a fine was issued, and not to be payable necessarily to the other party, but to the library fund. So I think the answer is yes. But one thing I'd like to point out in the difference in those situations is the court is able to hear testimony, understand all of the facts and circumstances, and make a determination in the child's best interest, as to what should happen, whether it even was an unjustifiable denial or whether the person was even in contempt, and if they were in contempt, whether it was just a technical contempt, but they should not be punished by incarceration.
Well, let me try to get at this a different way then. So this bill suggests that the remedies for failure to comply with a custody order should be A, written warning, B, civil fine, and C, incarceration. What does current law provide? What options does a judge have under current law in order to enforce the court's orders relating to custody? If it doesn't use warnings, fines, and incarceration, what does the court do currently in order to make sure that their custody decisions are complied with?
So under 9105, I'm not looking at that statute, but from my best recollection, the court can modify the custody arrangement, can order makeup time. Under contempt, the court can do those things, as well as incarcerate the individual or give them a fine.
Okay, so fines and incarcerations are possible currently under the current law.
Yes, exactly. That's why I don't think this bill is needed, especially this bill as written would be more harmful than good, but it's not needed at all.
Great, thanks so much.
Thank you, Mr. Chair. I think two of my questions were answered, but I just want to drill in on one thing. Ms. Ruth, you said something that I want to talk about, and that is that not always the details are not always laid out in the custody order, and when they are, sometimes they are changed informally. And the first thing when they're not always laid out, perhaps a custody order says, you know, this parent gets the child for a vacation for 1 week. So how would, under this, how would an officer be able to know whether that was the week they were supposed to have them or whether somebody was not following the custody order?
Senator Love, it's a good question, and I don't think we know the answer. So, I mean, if you just looked in my one-box file of cases that, you know, over the years, you'll see so many different models of custody orders where it's done by agreement and put in a separation agreement, and that's only referred to in the order. You'll see each parent is entitled to 2 weeks of vacation over the summer. They must give each other notice within 30 days of which weeks they want. If they don't agree, they'll go back to court or to a parenting coordinator or something to try and reach agreement about those 2 weeks. And then, you know, sometimes none of that happens or none of it works, or it all works fine, but then somebody gets upset about something, and it's the way it's written gives them the opportunity to try to punish the other parent. And so, I mean, I don't see how law enforcement could possibly do what this bill is asking them to do, given I don't want to say infinite because that's a really big number, but the really wide range of ways that custody is described, written about, unwritten, arrived at, and everything else. It just doesn't seem possible. I mean, I can think of so many examples in my head where it's just not going to happen on the basically the law enforcement officer is conducting a hearing on the porch to make a decision. And, you know, in another bill that was similar to this, there was also something about civil fines, and I never got an answer about where those civil fine money goes. If the law enforcement officer collects $500 on the front porch, where does he take it? To the court? Well, somebody suggested, one of the proponents of this bill suggested it would go to the local precinct, the $500, which did not seem very credible to me. So that's why this bill is not well written. But the bigger issue is custody is not cookie cutter, and it's not. Everybody doesn't follow every court order to the letter of the law every time, and a lot of the times that is fine until it's not. And my concern is for the people who don't know how to, who are going to be manipulated by that and have it used against them when they are the protective parent or they are the parent who's trying to do what's in the best interest of the child at that instance.
Thank you. One more question, Mr. Chair. There was also a colloquy about, couldn't the law enforcement officer call in and find out how many times a call had been from that home about not abiding by a custody agreement. To your point earlier, how would somebody who is in an abusive relationship, if the abuser were to keep calling law enforcement and say, my ex didn't drop the kids off, and maybe the ex was 5 minutes late, 10 minutes late, but if there's multiple calls, how is the officer going to know whether those are legitimate calls or harassing calls? How are they going to be able to parse that out?
I don't know how they're going to. It's another example. And when Senator Child asked the question, I wanted to say, just because somebody made those calls does not mean that there's a determination that the person did it willfully and knowingly. And I mean, you're essentially asking the law enforcement to be judge and jury standing on the door. So it is information. It is certainly information. Wow, these people have a conflicted relationship. He's called 10 times or she's called 6 times on him. But does that achieve the goal of this bill of saying, oh, it's clearly willful and knowing? I mean, maybe it's a lawyer in me, but when I hear those words, I hear a judicial fact finder determination, and not a police officer on duty who has to respond to a household. The other thing that we find in our area is that law enforcement has sometimes a different goal, and I think this would be asking them to do something that they're not accustomed to doing. Their goal is to de-escalate. Their goal is to make sure everybody is safe and okay. They are not really in the business right now, unless there is a court order of retrieving children from a house, for example, and taking them over to the right person who rightfully should have custody at that time. They won't do it until they get a court order, a judge who says you may use all reasonable force to retrieve these children from that house. This bill doesn't say they're doing that as well as giving a warning or as well as collecting a civil fine, but it's in the same arena. And I don't know how law enforcement is going to say, well, 3 times calling, that's not willful and knowing, but clearly if he had to call 6 times as willful and knowing, I'm going to issue you your fine today because it's the 2nd time I've had to come here. And I have no idea what the record keeping of law enforcement is, so I wouldn't even presume to say that this is easy information to find or not. I really don't know.
Thank you. Thank you, Mr. Chair.
Promise. You mentioned about law enforcement collecting fines on the front porch of $500. Have you ever been pulled over by the police ever?
Have I ever been pulled over? I've been pulled over unfortunately in my vehicle. I've been pulled over before.
Did you ever did they ever offer a ticket to you? Did you ever got a ticket for any driving infraction from a police officer?
I can remember one time, yes, I pulled an illegal U-turn with all 3 of my children in the car, and she gave me a ticket. But it was 20-some years ago. I don't really remember what happened next.
They didn't ask you to pay to the officer, right?
Oh, well, that's a good point. You're absolutely right. I see your point. They give you the fine and then it says within 10 days, send this money in or something. You're right about that.
Right.
You're right.
Not to a precinct or they actually have a location where you could mail your check into or bring it to the location.
Right. You're 100% correct. I hadn't remembered that, basically.
Or go to court. Right. So.
Yeah, or go to court, right? So, I mean, that begs another question, Senator. If I get my first $500 fine, do I get to dispute that in traffic court? Or, I'm going to go to district court and say it wasn't willful and knowing, so I don't want to pay this $500, and the district court's going to have to adjudicate that, and then if that one goes away, is the next one my second or is it my third? This bill, it's just ill-conceived. And this is recognizing that there is a problem sometimes with these cases. I don't think any of us in family law could dispute that there are problems in enforcement of custody cases, but this bill is just really problematic.
Well, that's why I say, and I said it earlier, I know I said it facetiously, but truly, you guys have been on one side of the coin, and then a lot of the advocates from my side have been on one side of the coin, and we have yet to really find a middle ground. And it's been over 15 years. I'm hoping that we can sit down truly with all the advocates. I know we've had different work groups that have been done, and it's been lopsided from the amount of people that have been advocating for shared parenting for all versus other pieces, and it was never done from a true balanced approach. I'm hoping we can get more balanced people to the table so all of us can come to an understanding, because your issues are very valid. Domestic violence is very real, and we want to protect folks from domestic violence issues. But there are real issues where people are acting out, doing parental alienation, keeping their children away from very good parents. These are real issues. You can have bad moms. It's okay for us to say there are bad moms, because there are bad dads as well. It's okay for us to say that. Not every person that is dealing with a custody issue is dealing with a domestic violence issue.
Right.
And so I think we need to stop conflating the two and come to a real balanced approach so that for the next 15 years, we're still not doing this, right? Let's come up with some resolution, because there's a lot of families that are being impacted by this. A lot of families. I remember having my son come to the State House, and Will gave him his first, Mr. Chair gave him his first button, legislature button, back in the day when I was testifying in the Judiciary Committee about shared parenting. And we still have not yet passed that bill.
No, and I don't think you're going to find support from the domestic violence community on presumption of shared custody ever.
Yeah.
And I don't know that the family law section would ever come your way either.
We need to find some middle ground on some things that make sense for families across the state.
How about expedited hearings and relocation?
Expedited hearings.
We worked on that together, didn't we?
Yeah. Expedited hearings are great, right? But that was only for when folks are leaving and moving out of state. But getting more expedited hearings, that's a problem with the judiciary. Not enough judges, especially in locations like Prince George's County, where you have court cases backed up for days, and you won't be able to get in front of a judge for 6-7 months. By that time, a precedent has already been put in place where whoever has the child has been the guardian of the child, and it's hard to change from that because now you're finally getting in front of a judge. So expedited hearings, if you guys would work with me on the expedited hearings, I think that'll address a lot of the problems.
I'd be happy to talk to you about that offline.
Yep. Thank you.
All right. Thank you for that, Senator. Senator McKay, did you have a question, or you're good to go?
The senator to my left.
He handled it for you. Beautifully. All right. Excellent. All right. All right. Seeing no further questions, thank you both very much.
Thank you.
Thank you. All right. With that, that'll conclude the hearing for Senate Bill 744. We'll move on to our final bill of the day, Senator James, with Senate Bill 906.
But it's all in favor. Just a minute.
Yep.
And is it okay if I'm joined by?
Of course.
Thank you.
Yes.
Very
Thank
good.
you.
Thank you. Members of the committee, Mr. Chairman, for the record, Mary Delaney James, Senator from Harford County, and I'm here to present Senate Bill, let me make sure I get the number right. Oh, Lord, I'm so tired. 906, because it's been many iterations of this. And I'm joined here today by Mr. Broadchurch and Mr. Welch. This bill has been around, I think. I can't vouch for whether it always looks exactly the way it is. I've been told that it might have been first introduced by former delegate Kathleen Dumais, who we very much respect as a judge. And first I'll tell you a little bit about it, but then I want to backtrack and just give you a more global picture on this. So the bill would apply only if the defendant in the current case had already been convicted of violating two other criminal statutes, one or the other, 602 and 603. One deals with distribution of drugs, and the other one does too, but it also adds equipment that you could use. The distribution goes directly to the person who is killed or seriously injured. So there's that chain. And if that happens, then under this bill, that person on this second related offense would be guilty of a felony and up to 20 years in prison. And that would be, it would be not concurrent, but consecutive. So that would be, making sure that society recognizes just how tragic and unexpected and depraved these killings are. And there's a lot of reasons for that. Let me just also tell you, there is an amendment. It's just a technical amendment. It lines the bill with the House bill. Look, I am not here as a witness. As many of you know, I could probably be a witness, but I'm not going to be. But I will tell you what that does. I have spent almost all my time in the House interested in mental health, addiction, helping people in this area. I worked long and hard to get buprenorphine into prisons. I'm all about harm reduction. I'm all about mental health. But with all of that, I have that knowledge, but I also have the knowledge that particularly fentanyl, if you want to focus where I would like this bill to end up, fentanyl is so absolutely different than any other drug that we've had out there, and it is appearing without anybody knowing it or understanding it, and that is why, for young people, the death rate from fentanyl has gone up 293%. There's no other drug in our history that has done anything like that. My background also was in psychology, so I came to mental health and child development. I worked with a very, very highly regarded child development psychologist. So I get the tragedy here too. I get the tragedy that young people, by their nature, from antiquity forward, probably pre-antiquity, and all of us are, but young people in particular have two things going. They're incredibly curious, incredibly excited to be experimental, and they have the lowest level of risk assessment. So this is another reason that fentanyl, this tasteless, odorless drug that could be the size of a grain of sand and drop somebody in a nanosecond, is so deadly and needs a response from our society as to why it's quantifiably different and destroying people's lives. So I really want the community, the committee to know, if there are harm reduction advocates here, I'm with you. I'm for safe places to do drugs. I'm for Narcan and any other drug that can reverse an overdose. I'm for other things that are going to come along. We don't want people to do drugs by themselves. That is not inconsistent and can live alongside the Maryland Supreme Court in State v. Thompson found that a drug dealer of heroin could be held liable for, I think it's called negligent homicide, if they were grossly reckless and they directly provided the drug. So we already have a court case at the highest level that has touched upon this issue. We ought to codify that, but particularly we ought to codify this drug fentanyl in particular. And I want to just say one last thing. If you hadn't seen it already, maybe some of you have read, like in Baltimore, the community in Baltimore that deals with drug addiction and harm is very aware that, first of all, you may have heard there were a lot of people just dropping down by one of the open markets. But then the scary thing that happened is in Philadelphia, they started seeing more and more people dropping on the ground or dying from yet another synthetic drug. And what is it? It's an animal tranquilizer. And so they are bracing for that to come down into Maryland. And my understanding is that drug, along with fentanyl, we don't have a way to mitigate it. We don't have a way to reverse it. We don't have a way to warn people about it. There isn't some adequate way to say, you're not getting cocaine, you're getting fentanyl. You're not getting heroin, you're getting fentanyl. You're not getting marijuana, getting marijuana and fentanyl. This is what we have got to be able to, walk and chew gum. We can do harm reduction, and we can also hold these depraved people responsible. Because remember, what drives this? There's nothing cheaper and easier to make with the highest profit margin than fentanyl. That's what's driving this depravity, and that's why we need to stand up and pass this bill. Thank you. And then I'll wait for the panel to speak. Are there any questions after that, sir? Right? Okay. Yeah, in the Senate. Have you been here? Yeah. Yes, that's right. You were here in the Senate.
Good afternoon. My name is Scott Broadfoot Sr., and I fully support Senate Bill 906, Victoria, Scotty, Ashley, and your daughter's law. The bill is named after my son, Scotty. On April 12, 2019, I lost my 21-year-old son, Scotty Jr., to fentanyl poisoning. Scotty purchased what he thought was cocaine. The cocaine had two forms of fentanyl mixed with it. The dealer who sold to Scotty was never charged or even arrested. The dealer had several prior arrests with charges relating to fentanyl. With this bill, the dealer would have been charged with my son's death. I fully understand that there's a lot of important topics at this session. Everyone in this room chose their position to help create laws to better Maryland. I have also chosen my role to make Maryland a safer place to live. Please help me understand why this is my third year presenting and testifying on this bill. Why hasn't it even been brought before the committee for a vote? Drug dealers must be held accountable for murder. Everyone has consequences for their actions. Since birth, we are rewarded or punished for our actions. Drug dealers are selling poison to our loved ones. Drug dealers must be held accountable. I will never see my son smile again. Thank you.
Good afternoon, Senators. My name is Stuart Welch, and I'm an Assistant State's Attorney with the Harford County State's Attorney's Office. I'm the Senior Contact Attorney for the Felony Guns and Drugs Unit and assigned to our County Drug Task Force. In 2025, for the first time in Maryland history, I convicted a drug dealer of second-degree depraved heart murder for distributing a fatal dose of drugs. I'm here today to request the committee to provide a favorable report on Senate Bill 906. Handling fatal overdose cases, I regularly meet with the families of overdose victims who carry a tremendous amount of pain. Had their loved ones died in West Virginia, Pennsylvania, Delaware, New Jersey, Washington, D.C., or any other of the vast majority of jurisdictions that already utilize drug-induced homicide laws, I would be able to pursue specific drug-induced homicide charges against the dealer. In Maryland, I'll have to go for manslaughter or depraved heart homicide charges, which is much harder to convict than if I had the specific charges like the ones introduced in Senate Bill 906. As part of my job, I often sit down with drug dealers for what are called proffer sessions. I have interviewed drug dealers from small-time to large quantity narcotic traffickers. One thing that they have in common is that they are well aware of the dangers of fentanyl, how common it is for fentanyl to be mixed with other drugs that they are selling. These dealers continue to sell these drugs anyways, despite the dangers. I personally provide expert courses on fatal overdose prosecutions and investigations, different jurisdictions across the U.S., including recently in New Orleans, Louisiana, and Chicago, Illinois. As I travel to these different states, I've seen the various drug-induced homicide laws that these jurisdictions already utilize, and I can attest that Senate Bill 906 is far more balanced and less strict than any that I have seen. Even Illinois, with a major jurisdiction like Chicago, has a much stricter drug-induced homicide law with much harsher penalties. Senate Bill 906 is extremely reasonable. and it is time that Maryland joined the great majority of states that already have laws like this. I respectfully request the committee to provide a favorable report on Senate Bill 906. Thank you, committee, for your time and attention on this important issue.
All right, thank you very much, Senator, and thank you for your testimony. Are there questions from the committee? Senator West has a question.
Thank you, Mr. Chair. I'm trying to figure what the current law is and how this bill would enhance the current law. Maybe the sponsor of the bill could help me out.
Well, I think I want the state's attorney to help me out. But,
Okay, well,
let's
let's
you know
get
I'm not a criminal. You and I both aren't.
Let's get the
what do we
state's
do?
attorney
Yes.
up there.
Yes, I can come.
And then
So-
I don't know if you want to read that, but we should all read State v. Thomas.
Yeah, no, the state's attorney is, it would be
But he is,
much better because the law.
Yeah, I'll field any questions regarding
The laws are detailed, I know. So we currently have laws on fentanyl. So what are the current criminal penalties for, I guess, using/distributing fentanyl, and how would this bill increase those penalties?
Right, so what we have in regards to fentanyl specifically, and also mixtures containing fentanyl currently, so we have obviously the direct distribution or possession with intent to distribute charges right now, which is the 20-year penalty when we're dealing with fentanyl as a Schedule II controlled dangerous substance and narcotic. On top of that, there is also, it's an enhanced penalty statute which deals with if you are trafficking either fentanyl specifically or a mixture containing fentanyl. Sometimes, a lot of times, we have what's called polydrugs, which is multiple drugs in one, multiple substances that also include fentanyl. So in that case, if they're convicted of both of those, the state's attorney can seek a 10-year enhanced penalty for the distribution involving that as well.
So up to 30 years?
Oh, sorry.
Up to 30 years?
Up to 30 years if it's a conviction for both of those. I believe by case law, they have ruled, and I'd have to check that to confirm, but I believe that the state's attorney at this point is allowed to ask for the 10 years to run consecutive to the up to 20 years that you can get for the distribution or possession with intent to distribute.
Okay, so now we come to this bill.
Yes.
If this bill is enacted, how do the penalties change? And what would be the triggering factor which would cause the change?
Yeah, so this bill is similar to those, like I said, there's other jurisdictions already have this bill similar to this, like in Chicago, Illinois, where it would be, again, it would be an enhanced penalty. It would basically be able to run consecutive to whatever you're able to convict. So if it's a distribution for fentanyl, the maximum would be 20 years for that if we could convict on that. If it's also conviction of this, under this bill as well, it would be an enhancement, possibly up to 20 years on top of that for this penalty.
And the triggering event is the death or the serious bodily injury of someone who ingests the fentanyl?
That's correct.
Gotcha. Okay, thank you.
Yes, absolutely. I'm happy to answer any other questions. Yes, sir.
Thank you, sir. Yes. So in section 4-204, it allows for the prosecution either the county where the distribution occurred or the county where the death occurred. What happens when one county is distribution and another county is the actual death? Is there some form of like a mechanic?
Yeah. Yes, absolutely. We deal with this and other issues as it is currently. I mean, this is definitely a situation I've actually dealt with specifically in a case that we were contemplating charges but did not end up actually charging. This would actually bring more clarification on this. A lot of times what happens is people, especially in my county, in Harford County, the people in our county are getting their drugs out of Baltimore, so a lot of times they're either going themselves or having someone come to them, but a lot of times they'll go to a neighboring county, Baltimore City. They'll get the drugs there. They might come back, take the drugs in Harford County, and then it becomes an issue of, well, they passed away in Harford County, but the act of the actual distribution happened in Baltimore City, Baltimore County. So where would we bring the charges? At least with this, it would really be, I mean, there would have to be collaboration, obviously, between the state's attorneys, which we do often on other cases for drug-involved cases. So in that case, it would be really up to wherever they want to bring it, but it would be, we would not be able to bring separate, same charges in both counties, basically. It would have to be one or the other, and then they would have to work together.
Okay. Thank you, Mr. Chair.
Yes, absolutely.
All right.
I'd like to just one thing.
Of course.
Senator West, which is, I don't like unnecessary symbolism. But the reason I think this bill is important and powerful, in addition to what the state's attorney said, first of all, most people don't get these top numbers anyway. But when you tell a parent of a child who's just dropped dead that we'll get this guy for distributing a controlled substance, blah, 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 it is quantifiably different, and it does not feel like the state understands or is listening to you when it's the death of your child. So to be able to say, we are prosecuting this guy for killing your child under this statute, which says he was grossly, negligently murdered your child, right? That's the difference. And we can have several statutes coming in different ways, and this prosecutor doesn't have all day to tell you that he, decides how to combine them. But it's, to me, very important that we have something on the books that understands that these deaths are like nothing else, and we ought to recognize it. Thanks.
I want to thank you for that.
You know what I mean?
I think with the state's attorney's clarification, I know exactly what this bill is getting at, and I think it makes every bit of sense. And I thank you for presenting the bill.
And Senator, if I may add to just the answer for that question also, I would just add that, like I said, I've seen the jurisdictions across the United States. I can say that the vast majority of them that I've seen are usually 40 years, so the 20 years is actually even a lesser penalty than I'm used to for seeing for one of these bills. So.
Excellent. Thank you. Further questions from the committee? All right. Thank you, Senator. Thank you. Mr. Broadfoot, again, thank you for, I always say this, but you're taking one of the most difficult moments, or the most difficult moment in your life, and you're transmitting that into action and advocacy. So I just wanted to say thank you for, what you're doing and your continued work on this. So thank you very much for your testimony. All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. We'll hear from Jesse Dunleavy and Eric Sterling.
Chairman Smith, distinguished senators, on behalf of the Law Enforcement Action Partnership, we appreciate the opportunity to testify in opposition to SB 906. For 9 years, I was counsel to the U.S. House of Representatives Committee on the Judiciary. I wrote federal drug statutes, and particularly the Anti-Drug Abuse Act of 1986, with its mandatory minimum sentences for distribution of a drug resulting in death and for distributing crack cocaine and other drugs. For more than 40 years, I have worked with families that have suffered from the tragedies of substance misuse. Their suffering is terrible to endure, and I know firsthand my cousin Cliff Sterling was one of those who died from a drug overdose. But I'm also deeply aware that these well-intentioned statutes can become legal and financial disasters. The mandatory minimum sentences that I wrote in 1986 have led to hundreds of thousands of unjustly long imprisonments with gargantuan racial disproportionality. And fentanyl was included as a mandatory minimum in 1986. Please read my written statement, which explains our arguments more than I can do in 2 minutes. SB 609 is unnecessary. We already have 3 narcotics distribution offenses in Maryland law, which allow for the imposition of up to 50 years for distribution of heroin and fentanyl, depending on quantity or role of the offender. This bill is going to cost tens of millions, maybe hundreds of millions of dollars. The fiscal note on this bill last year, I believe, underestimated the number of people the statute is going to cover. The estimate of 8 cases per year statewide doesn't make sense. That tiny number of cases isn't what the sheriffs or the state's attorneys have in mind. Even if 16 persons are incarcerated per year, after 10 years, the state will have spent well over $50 million just incarcerating these few offenders. To save lives, there are a lot better uses for $50 million. Sadly, because there is no Good Samaritan Act coverage, this bill is likely to increase the number of overdose deaths. And other states with similar bills have perpetuated racial injustices, with prosecutions focused on the deaths of white persons, not persons of color. For these reasons, we urge an unfavorable report. Thank you.
Hi, thank you, Chair Smith and committee members, for letting me speak in opposition of this bill. My name's Jesse Dunleavy. My son, Paul, died of a fentanyl overdose in 2017, saddled with a language impairment that hindered his ability to communicate. He was isolated. His teachers loved him. He was sweet and kind, and he was loved at home, but otherwise he was marginalized and often bullied. His feelings of inadequacy grew, and as he got older, in his 20s, he turned to self-medicating. The discovery of a drug that at first provides relief, little do they know that it leads to so much more suffering. At one point, he was incarcerated, and while there, he was hungry, he was robbed, and he was targeted because of his vulnerability, and he was sexually abused. The setback cost us years, but by the time he was 32, he had a job that he loved, and he had his first apartment. At 34, he relapsed. He used with another. I don't know which one of them supplied the drugs. I do know money changed hands. Had it been Paul that supplied the drugs, I know that he would not have had knowledge of any additives, nor would he have ever had a sinister intent. Had the other person overdosed, the thought of Paul in prison for so many years is unbearable to me. Frankly, it's worse than his being deceased. I thank God he spared a system where cruelty is the norm, where dehumanization rules, and where the weak are exploited. Some violations, sadly, prompted by the stranglehold of addiction, do warrant incarceration, but a murder charge, regardless of naivete or intent, is extreme. It will victimize the marginalized, the poor, the Black, the disabled, and I walk beside every parent who has lost a child to overdose. I breathe and live their pain every day. This bill will not save lives. The research is convincing. Please do not pass it. Thank you very much.
All right, thank you very much. Questions from the committee? Again, Ms. Dunleavy, same sentiment, just say thank you from the committee for stepping up and advocating. It's interesting, you know, people have had similar experiences but are on opposite ends of the issue, which I think makes this just a very complicated problem set for us. But I want to say thank you for us. Thank you from us to you for your advocacy.
Thank you. It's a very painful situation, and my heart does go out, too.
Yeah. All right. Seeing as though there are no questions from the committee, thank you all very much. That'll conclude the testimony and the hearing for Senate Bill 906 and our hearings for the day.